How can I prove employer retaliation after an EEO complaint? Imagine you've just filed a complaint with the Equal Employment Opportunity Commission about workplace discrimination. Now, your employer starts treating you differently. How do you prove they're retaliating? That's what we're here to figure out. First, you need to show you did something protected under the law. This includes filing an EEO complaint, participating in an investigation, supporting a coworker's complaint, or opposing discrimination. These actions are protected because they help enforce workplace fairness. Next, you must prove you experienced an adverse employment action. This can be getting fired, demoted, receiving a pay cut, negative performance reviews, being excluded from meetings or opportunities, or even increased scrutiny. Basically, anything that discourages you from speaking up or participating in investigations counts. Then, you need to connect the dots. Show that the negative action happened because of your protected activity. If the adverse action occurs soon after your complaint, that timing can suggest retaliation. Usually, if something negative happens within a few weeks or months of your complaint, it looks suspicious. Gather solid evidence to support your claim. Keep copies of your EEO complaint, emails about your complaint, or notes from meetings where you raised concerns. Save any notices of termination, disciplinary warnings, or changes in your job duties. These documents show what happened and when. Timing is important. If the negative action happens right after your complaint, it's a sign of retaliation. Statements from supervisors that link your complaint to your treatment are strong evidence. For example, if a manager says you're being disciplined because you caused problems by filing a complaint, that's direct proof. Witness testimony can help too. Coworkers who saw your treatment change or heard comments about your complaint can support your story. Also, look for patterns. If other employees who filed complaints faced similar negative treatment, that suggests retaliation. Watch out for pretext. If your employer gives a reason for the adverse action that doesn't match the facts, that's a red flag. For example, if you're fired for poor performance but recent reviews were positive, the employer's explanation might be false. To strengthen your case, keep detailed records. Note dates, times, what was said or done, and who was involved. Save all emails, texts, or memos related to your complaint or treatment. Document any sudden negative reviews or exclusion from meetings. If possible, gather statements from coworkers who can confirm your account. Also, pay attention if your employer's reasons for the adverse action change over time or don't match company policies. These inconsistencies can support your claim. Remember, the burden of proof starts with you. You need enough evidence to show retaliation probably happened. Once you do, the employer must then give a legitimate reason for their actions. If that reason doesn't match the facts or seems false, you can challenge it. Proving employer retaliation takes careful documentation and attention to detail. The more evidence you collect, the stronger your case will be. Stay organized, stay persistent, and know your rights.